There were a number of people who were involved in the formulation of my first witness statement. My team, counter-terrorism police, legal advisors. I sought clearance from the then Cabinet Office Permanent Secretary, the National Security Advisor, and I cited the then Prime Minister. After the charging decision, I was told that I wasn't able to share my witness statements because it may pervert the course of justice. I was a witness in a criminal case. I took that obviously very seriously, and so the preparation of witness statements 2 and 3 were done by that same small team of within NSS and with my legal advisors in consultation with counter-terrorism police. Well, I was asked to include reference...
You were asked to include it?
I was asked...
Well, that's what I wanted to get to grips with.
Okay. I was asked to include a reference to the new government's policy by counter-terrorism police for fear that there would be a wedge driven between my witness statements and the new government's policy. I did that. And just as a point of fact, I drew from an answer to a parliamentary question rather than the Labour Party manifesto. So the meeting on the 1st of September
with Sir Oliver Robin
involved a range of different civil servants and operational partners. It was to discuss a range of China issues, including the handling of this case. There were at least 4 lawyers in the room who ensured that there was no discussion about the evidence that was going forward in the case.
You said you were disappointed by the dropping of the case, but you couldn't have been surprised that this was going to be the outcome, could you?
So I was a bit surprised, actually. I always knew it was going to be a challenge. When we discussed it with my team and with operational partners way back in 23, it was always going to be more of a challenge in this case than the other case that I gave a witness statement to. That's because of the nature of the actor and the nature of the incidents in question. But throughout the period from the submission of that first witness statement until I was informed that the intention was to drop the case, I was trying to ensure that we could support a successful prosecution. And so I was somewhat surprised when I was told on the 3rd of September that the intention was to drop the case. What I said I would be able to say is that China poses a series of threats to UK's national security. These include espionage threats, cyber threats, threats to our democratic institutions, threats to our economic security. I believe what they were asking me to say was to use the generic term that China is a threat or China is an active threat, which is not in line with government policy at the time. However, the way I would have answered the question under cross-examination would have been to go through all of the areas where I've specified in my witness statements, and I would do again so verbally, the range of threats that we see from China. So every time a request came in for more information, myself, the team working with operational partners did our best to service that request. I was advised throughout by external counsel, and I discussed several times with my legal team whether we felt we had given enough. It was his advice that he thought we had. You might want to ask him, he probably still thinks we have.
I don't think it is a question of blame. The responsibility of prosecutors is to place cases before the court on the basis of sufficient evidence to secure a conviction. And ultimately, the issue in this case is that we were not able to provide the evidence to sustain the case in respect of one essential element, which was the element that China was an enemy, as was required by the statute.
Well, did you ever get the feeling that the government wanted this case to fail?
Nothing reached me. I should, I'm sure it's known to many members of the committee, but if I may just explain the division of responsibilities in terms of criminal cases. So we don't investigate cases. We look at the evidence and we make decisions about whether it meets our tests. But the relevance of this to your question is that until a very late stage, we weren't engaged directly with any witness. That was the responsibility of the police. So I do not know anything about the background to the statements that were produced. Our responsibility was to look at the evidence, to ask investigators to obtain more evidence if that was possible, and then evaluate whether our tests were met. And the key test for prosecutors is the evidential test, which is there a realistic prospect of securing a conviction?
So just dealing with a couple of matters that you've raised, perhaps to try and join up some of the dots. The critical meeting, which was an unusual situation for leading counsel for the Crown to meet a witness in these circumstances, and I did that on the 14th of August, and I have a very clear recollection of that meeting because I needed to understand why the two previous attempts to get statements, statement number 2 and statement number 3 from Mr. Collins, why, as it were, what I thought would be relatively straightforward to be said, which was there was an active or current threat to national security, why that hadn't been articulated in clear terms. I also want to make it clear I was not concerned if the witness didn't use the word enemy. That would be a matter for the jury. But I needed to have the evidence to support the submission to the jury. And the witness was clear to me that he would not say that China posed an active threat to national security at the material time. That was in answer to what I regard as the million-dollar question in the case. And once he had said that, the current prosecution for those charges was effectively unsustainable. That's my carefully reflected position. I didn't jump to that immediately. I advised on the 22nd of August, having reflected over it as far as those charges were concerned. There was other discussion then about alternative charges, but I don't think anyone should misunderstand the effect of what the witness had said. That would have been disclosable, and it brought this case effectively to a crashing halt as far as that was concerned with that witness, who is the Deputy National Security Advisor to the Cabinet.
And the conclusion that was reached by Mr. Little and by our team was we were in that place. So this case would not have got to a jury because our professional assessment was that we were unable to satisfy that limb. In view of that answer,
I just want to know the basis upon which you were deciding that you needed to get more evidence. As I say, there might be many people, ordinary members of the public, who would be bringing common sense to this, this event through a jury, who might think large-scale spying on the UK, by China looks like the actions of an enemy to me. Yeah. So what changed it, you say, was Rousseff. But don't you agree that the Court of Appeal said that it wasn't going to, this is in the case of Rousseff, that they weren't going to establish a new meaning of enemy, that the term enemy should be approached in a common sense way. Now, lawyers know common sense way means that's why we have juries, because juries have so much more common sense than lawyers, frankly. And we need to get the jury to have a look and decide whether or not someone is an enemy. So Rousseff is specifically saying we need to approach the idea of what is an enemy through a common sense way.